3, Lord, has served its purpose. The day Constituent Assembly of Jammu and Kashmir agreed that yes, Article 370 must remain on the Constitution of India, subject to following modification, and President accepted and issued that modification in Lord CO 44. That's the end of the story. Lord, your lordships have taken the view right from federal court, and I will show Lord series of judgment that temporary statutes, Lord, General Clauses Act does not apply. If that is so, then Lord, the exercise is one-time exercise. You cannot exercise it again and again. It was never intended to be exercised again and again. Now, if it is not a continuing exercise on a demurrer, in my respectful submission, then Lord, the only way Parliament could do it is by amending the Constitution under Article 368 and repealing Article 370, and in no other manner. And I will show, my Lord, that's the view, Lord, 8 of your lordships have taken in Berubari's case, where your lordships, Lord, interpreted a treaty and said that you cannot do this unless you amend the Constitution. And lastly, it's going to be my respectful submission for your lordship's kind acceptance that the exercise of powers by the President on 5th of August and 6th of August 2019, Lord, are nothing but fraud on the Constitution. As Dr. Dhawan rightly points out, there is nothing on record why a provision which has successfully survived from 25th October 1947 till Lord 6th of August 2019 should have been Lord repealed, as they claim, or should have been withdrawn. There was no material whatsoever. The only material with respects was that the ruling party in its manifesto in 2019 had said, we will abrogate Article 370. Your lordships in DC Wadhwa's case have said that you cannot exercise constitutional powers to achieve political ends. Lord, it's a classic case of fraud on Constitution. So, Lord, you have a government in Lord association with a local party in Jammu and Kashmir. It is working well. You suddenly withdraw the support from that government. Then you persuade the governor to issue president to issue a 356 order. Then you persuade president to issue a resolution of the assembly. You, Lord, Parliament then apparently takes control of legislative and executive functions, and then you say, now President will exercise all powers into one and Lord pass orders under 370. Lord, what more classic example of abuse of power than this can be? Lord, as Chief Justice Coke said, Lord, way back when the fight began with the king, that Lord, king can do everything except making a man a woman and a woman a man. Lord, surely President could not have exercised these powers under 373, assuming himself to be everything. What Lord, yes, Lord, has been pointed out at great pains and very brilliantly, that Lord 356 is a temporary provision. Now, Lord, 356 being a temporary situation, can you take actions which are permanent, Lord, or permanency, or permanent in nature? Forget anything else. Because Lord 356 itself says that everything that you have done in the interregnum will come to an end. And maximum period for which you can exercise 356 is 3 years. So, Lord, to do this, Lord, in my respectful submission, it really strikes at the very basic, Lord, features of our Constitution. Democracy, federalism, Lord, Government of India in their affidavit before your lordships categorically admits this, and this is very important, Lord, the counter, which I'll read at Lord appropriate stage, that Constituent Assembly of J&K did not in any manner deviate from the provisions of the Constitution of India, which would be applicable to J&K. This is their Lord profound statement. Then Lord they try and Lord they say that Lord ultimately that what we have done is because of national interests. Therefore, nobody knows what this national interest is because it's not been defined in their counter affidavit. There was no material whatsoever. As I said, Lord, it has survived. Of course, there is insurgency. Nobody can deny that. But then we have insurgency in so many states in Northeast India. We had insurgency in Punjab for a long time. If we were to start not disintegrating states into union territories in this manner, no state will be safe in this under political class that we have today. Tomorrow it may so happen that my party cannot get elected in a state. I will disintegrate into union territories because there is law and order problem. This is something which your lordships will have to very seriously consider. It's not just one-time exercise. It has such broad ramifications for future of India, for the Constitution of India, for federalism, for very existence. That it will really be giving now this kind of a power to a majoritarian government will be destructive of rule of law. It would be terribly destructive of rule of law. And I beseech your lordships, that's why in Coelho, your lordships have very beautifully put it, that constitutionalism demands that your lordship should oversee every act of the parliament and the executive. And the moment your lordships will find that there is infraction of constitution, your lordships will come down heavily on them. It's all right to create this atmosphere of fear all around. Nobody, one thing I must tell you, Lord, is very interesting. Very few people, way back on 27th May 1949 in the Constituent Assembly, a debate was going on about bringing 4 representatives of J&K who had not been invited so far. Question was whether they should be nominated or not because everybody felt that they should be present. So Mr. K.T. Shah, who was an advisor to government of Jammu and Kashmir and who had Professor K.T. Shah had worked there very extensively, he made this statement which was very interesting, which was perhaps quite inappropriate. He said, it has been the declaration of highest authority of India and also that of accession of the state made by the Maharaja, who was the complete constitutional head on the day that accession was agreed to, was subject to confirmation by result of plebiscite. Now, please see Pandit Jawaharlal Nehru's retort to that. Jawaharlal Nehru retorts by saying this is absolutely incorrect, 100% incorrect. I am amazed, surprised and astounded that such a statement is made by Professor Shah. Why? Because Kashmir had certainly become part of India and it will always be a part of India. Nobody denies that. Article Section 3 of the Jammu and Kashmir Constitution itself provides that we are part and parcel of India. Question is that when you have now, as your lordships have very rightly questioned about sovereignty, you can acquire a new land by either accession or by cession or by occupation. In each of these cases, you can take away complete sovereignty, as my Lord the Chief Justice observed. But what happens in a situation like this, where you have agreed as a nation, as a dominion, as a state taking over that territory, that I take your territory subject to this condition. What happens then? There, Derubari says that you cannot now get out of those conditions. And the only way you can do it is by amending the Constitution of India. Now, you don't want to amend the Constitution of India because then you have to follow the procedure. You need 2/3 majority in both houses. You may even need, my lord, to go to the legislatures of the state because you are taking away representation of the state in Lok Sabha and Rajya Sabha. So you will need, my lord, 50% of the states to agree to that provision. So, my lord, these are the safeguards. If these safeguards are thrown out of window in this light manner, who else can protect except your lordships? So, my lord, it is very therefore important for us to understand that, my lord, this is not just about Jammu and Kashmir. Jammu and Kashmir was, is, and will always remain part of India. But, my lord, the promise that India made to Jammu and Kashmir, the cession which came about on terms and conditions, how do you interpret those terms and conditions? So, my lord, your lordships are called upon to expound this constitutional provision, which in my respectful submission is, and I must tell your lordships that Premnath, first, your lordship said that yes, we have to await the confirmation by the Constituent Assembly. I will show those passages. Then in Sampat Kumar, your lordship said, Constituent Assembly has given that assent. People have agreed to abide by this, and President has accepted that. So both ways your lordship's court in these two judgments will not give a complete finality to what is the eventuality under Article 370, sub-Article 3. So, Lord, in my respectful submission, this calls for a very different kind of approach than what government of India would like your lordships to take. Lord, that's an extremely, I would say it's a narrower approach. That's not how constitutions are interpreted. They have to be, these are durable provisions. They must go through the test of times. If merely because something has happened or is happening in Jammu and Kashmir, you have to do this, then it may happen in another state and you might be called upon to do that again. So, the power cannot be exercised because of certain situation prevailing at a particular point of time. Constitutional provisions can't be tinkered with in that fashion. So, how do you make them durable? You make them durable by really understanding. But the need of the hour was that we wanted Kashmir to get into us, Jammu and Kashmir. So, at that point of time, we were left with no option but to accept what they offered us. Otherwise, we were afraid Maharaja might run away to. There was one fear that he might go to Pakistan. He might join Pakistan. So, nobody knows what exactly was happening, but who were the people who really were aware? The constitutional framers. And Dr. Iyengar's exposition of 370 is really the complete answer. Although, I am conscious that Constituent Assembly debates may or may not be relied upon, but it gives a complete answer to what government tells us on 370. He also says that all that we need is the wishes of the people expressed through a Constituent Assembly. Once that wish is expressed, it's the end of the matter. He says that, and I'll read that two paragraphs of this. So, whichever way one looks at this provision, in my respectful submission, this controversy needs a very, very delicate approach from your lordships, so that we do not end up creating a situation. Today, let us assume for the sake of argument that today this decision is in national interest. Let us assume for the sake of argument. Tomorrow, some other political party in power with majority may try and take a decision which is not in national interest. You have to therefore lay down law which will stop all these exercises for all times to come. And that's where constitutionalism comes into play. And I beseech your lordships with all humility at my command that your lordships may therefore look at it this way. Now take therefore in this regard, kindly turn straight away to one judgment of your I have a compilation of judgments which are new, but you can also, Prasanna, you can add them. We can. It is already with Prasanna. I can add them with just in 1 second if your lordships permit.
It's part of the existing compilation now.
It's not with your lordships, it's with the Learned Courtmaster, volume 30. 130 case law. 13. Case law
So
compilation.
what is volume
From
29? We stop at volume 28.
29 and 30 have not been allowed by the chiefs. These are judgments only.
Judgments are in the compilation?
Dr. Dave is.
Mr. Dave.
Sorry,
Mr.
sorry, Mr. Dave.
No.
I'm sorry.
Many of them are, but 5 of them are not. Which, Lord, your Lordship knows not. Our research goes on all the time.
That's Mr. Dave, but at some point of time, you have to freeze it all. Otherwise,
These are judgments. Your Lordships can't certainly stop us from
Why not?
fighting judgment.
But we had-
Submissions, yes, I agree. But
But
Lord,
even
we have-
judgments, should it not be frozen when you submit written the
it's not easy.
compilation?
It's not easy to do it. Let me tell your Lordships honestly. Because this is a thinking process. We are constantly thinking and constantly rethinking and rethinking and rethinking. Lord, to find 5 judgments, I have seen more than 500 judgments. I can assure your Lordships.
If we apply this principle to ourselves on the lighter side, then we'll keep on thinking, not produce any judgment, and keep on thinking only.
Lord,
All that will happen.
Lord, your Lordships, once the matter ends, certainly we'll be thinking many a times over.
Yes, but we see.
But at some time, we have to also say, all right,
No,
now,
that's
this is the guillotine. Now, I'm not going to think anymore.
All right, when my arguments are beginning.
All right, but if so many of your judgments are repeated in the compilation already.
I am not repeating.
So
Those
then
are there. Those are there.
which are the 5 judgments which are not in? Then
Yes.
just the judge.
Judgments which are already given, I am not.
Actually, the back office work has to be done before the argument.
Much before the arguments, otherwise it becomes
So
impossible.
the way the problem is, if you are a singular
Lord,
counsel arguing.
Lord, once the debate begins in the court, your Lordships put questions.
Mr. Dave, what happens is that's why if we don't do this, essentially difficult matters will never get argued because the whole purpose is to restrict time. If you don't restrict time, we cannot carve out time for big matters.
I have promised 1.5 to 2 hours, I'll finish it. I am not going to take a
Concern,
minute
Mr.
from-
Dave, if you were the only counsel, it doesn't really make so much of a difference because you added something, subtracted something. When the multiple counsels, 10 counsels, 12 counsels, each person starts doing it, where do we go? This is the concern only.
Lord,
It is
but
not that we wanted to shut
law
out. this-
declared by this court, my Lord, your Lordships would always like to see. It's law declared by your Lordships court, my Lord.
No, but I mean, there has to be a certain procedure also and orderliness in making
Every
something.
year, SEC online creates some 19-20 volumes. This is another problem.
Well, I'm sure, Lord, when your Lordships directed us to give submissions, we never thought that, Lord, so far as judgments are concerned, because it's a constant research. Nobody can, Lord, do it at one go. You are trying to find out again and again and again answers. Questions fall from your Lordship's, Lord, bench. So, Lord, to that, your Lordships rightly asked about sovereignty.
Volume 20. 2 volumes, Mr. Dave.
I don't know, 29 is by.
29 is Mr. Nowadays. That has also not been allowed by the board.
This is the problem. How can we do this?
Then how many volumes will we have actually?
It is
We should be actually having 1 volume now of case law.
28 is
My 28 was allowed already earlier, but 30 is not an additional one. How many judgments? 30. I have brought printed copies also, if your Lordships like.
So volume 30 is 5 judgments.
5.
29 also has just case law, right?
Yes, yes, Lord. There are no submissions. These are only judgments. Lord. 28, 29, 30 are case law compliance.
All right, you can.
Some,
No, my apologies for it, but Lord,
What sauce for the goose is not sauce for the gander. So you will not.
I'm sure Lord, Mr. Mehta will definitely like to cite Lord new judgments to counter
I don't
us.
think so.
His-
He's not saying that I'm going to cite it. Don't give him ideas.
Lord, his smile tells us otherwise, Lord.
I learned it when they signed.
What is it that you want to cite? All right, Mr. Dave, let's quickly run through it. Give us, give us those. Why don't you give us the soft copies? Huh?
It's in the drive.
यहाँ पर है. Judgments or
No, yes, Lord, I would like to.
fellowship charity? Is it that you want to, why don't you then give the judgments in 10 minutes that we have today? You can really give us the framework. What are the judgments you want to cite? What is the principle? Just formulate the principle.
As I said, Lord, the three points that I want to urge. One is that Lord, 370 by itself, Lord, is a self-exhausting provision.
All right, then what are the judgments? Just tell us the citation.
Lord, Dalmia
Volume 29 page.
Lord, 1959.
Volume
SCI,
30, right? Volume 30.
PDF,
Just give us the PDF page.
Lord, PDF page 16161,
No, it can't be 16161.
page 2. Volume 30, page 2. You proper page. You sit down and you.
Volume, what is the site? What is the name of
Lord,
the
this
case?
is Dalmia Dadri Cement versus CIT. Lord, this interpreted this very broad letter of accession and said that this is a treaty. And Lord,
Para?
yes, Lord, paragraph 3, 5, and 8. 8.2.
82.
Yes.
Why don't you read out the relevant part, Mr.
Yes.
Let him read it out.
So, Lord,
Yes.
now, Lord, here, your Lordship say, and I what fell from the Honorable Chief Justice.
What did it
Lord.
interpret? Interpreted?
Sorry?
What did it interpret, you said?
Lord, interpreted the accession agreement and Lord held it to be a treaty and then said sovereignty should transfer.
Sovereignty transferred.
Yes. But Lord, in the subsequent case, Lord, in Berubari, which is already on record.
Now, Berubari, where will we get the site?
Yes, Lord, Berubari is at, Lord, I'll tell you, Lord.
Which case law compilation?
PDF page.
Of volume?
Yes, Lord. It is PDF page 13, CLCP 492.
No, what is the volume?
13, page 492.
Volume 30 or 13?
13,
Volume 13, page?
92. 492.
Let's
Now, Lord, this will have to be read in extenso because this is a brilliant, Lord, exposition of a treaty and why, my Lord, your Lordships held that you cannot get out of this treaty except by constitutional amendment. Give me the page. When I interpret, there is a condition. Volume 13. Don't ask.
Volume 13?
I am Lord. Your Lordship knows, Lord, that Mrs. Dave had to assist me. Your caused embarrassment to your Lordships at that point of time. Lord, my Lord, that's why I proudly call myself technologically
It's
challenged.
so simple, Mr. Dave. Just try, give it a try for one day and you'll never go back.
Try to encourage you on the lighter side by saying I had an equivalent mind block to it. And among the mind blocks I had, I used to tell the chief, see, don't deprive me the privilege of, after a miscellaneous matter, throwing the file down. That's the only privilege a judge has after a badly argued matter. But but in these kind of matters, I mean, having done it last time, I realized that the volumes become so many in a small matter it's fine, but in a bulky matter
No,
it works better.
This is the thing.
It works better.
Now,
So we
there
are
is no
encouraging
doubt
you,
about-
Mr. Dave, that please get on board.
Well, I am giving your lordship PDF pages.
But that is what your junior is relaying to you. You have to give it to us yourself.
I told you, Lord, that word I don't take away, please from me.
Volume 13, page 492. Berubari.
Yes, Lord. I turn to. In view of our conclusion. Yes. Lord, Lord, yes. What para 31? My lords have got it. May I read it, please? What then is the nature of the treaty making power of a sovereign state? That is the next problem with which we must consider before addressing ourselves to the questions referred to us for our opinion. As we have already pointed out, it is essential attribute of sovereignty that a sovereign state can acquire foreign territory and can, in case of necessity, cede a part of its territory in favor of a foreign state. And this can be done in exercise of its treaty-making power. Cession of a national territory in law amounts to transfer of sovereignty over the said territory by the owner state in favor of another state. There can be no doubt that such cession is possible, and indeed history presents several examples of such transfer of sovereignty. It is true, as Oppenheim has observed, that hardship is involved in fact in all cases of cession the inhabitants of the territory who remain lose their old citizenship and are handed over to a new sovereign, whether they like it or not. And he has pointed out that it may be possible to mitigate this hardship by stipulating an option to emigrate within a certain period in favor of the inhabitants of a ceded territory as means of averting the charge that inhabitants are handed over to a new sovereign against their will. But, now see me not these words, and I place them for your lordship's acceptance. But though from the human point of view, great hardship is inevitably involved in cession of a territory by one country to the other, there can be no doubt that a sovereign state can exercise its right to cede a part of its territory to a foreign state. This power, it may be added, is of course subject to the limitations which the constitution of the state may either expressly or by necessary implication impose in that behalf. In other words, the question is to how treaties can be made by a sovereign state in regard to cession of national territory, and how treaties, when made, can be implemented would be governed by provisions in the constitution of the country. Stated broadly, treaty making power would have to be exercised in the manner contemplated by constitution and subject to limitations imposed by it. Whether the treaty made can be implemented by ordinary legislation or by constitutional amendment will naturally depend on the provisions of the constitution itself. We must therefore now turn to the aspect, that problem, and consider the position under our constitution. In dealing with this aspect, we are proceeding on the assumption that some legislation is necessary to implement the agreement in question. Then lordships may omit 5-7 lines and please come to the words unlike other federations.
But before that, something very interesting. The Attorney General, appearing for the Union of India, in that case, argued that there is something called the basic structure.
Correct.
Just see that the learned Attorney General has asked us to bear in mind the special features of the basic structure of the Constitution
Correct.
in construing the relevant provision of Article 3. He contends that the basic structure of the Constitution is the same as that of the Government of India Act 1935.
That's how, not right, 60. 60,
Yes.
60. Mr. Setalwa, he alone could do that. Now, please see, Lord. Unlike other federations, the federation embodied in the said act was not the result of a pact or union between separate independent communities of states who came together for certain purposes and surrendered a part of their sovereignty. The constituent units of federation were deliberately created, and it is significant that they, unlike the units of other federations, had no organic roots. Hence, in the Indian constitution, by contrast with other federal constitution, emphasis on preservation of the territorial integrity of constituent states is absent. Now, my lord, this is important. But now, my lord, kindly turn to paragraph 44 at page 515. How does it begin? Yes.
Just read the lower portion.
Yes.
also.
Just read what, my lord?
The paragraph 32, the lower portion.
In fact, you can start reading
Yes.
from, in fact, it is well known, and then go to the end, as my learned brother says. In fact, it is well known. Last 10 lines. Is directly goes against it.
That as a result of States Reorganization Act in place of original 27 states and one area which were mentioned in Part D in first schedule to the Constitution, there are now only 14 states and 6 other areas which constitute Union territory as mentioned in first schedule. The changes thus made clearly illustrated the working of peculiar and striking feature of the Indian Constitution. There may be some force in this contention. It may therefore be assumed that in construing Article 3, we would take into account the fact that Constitution contemplated changes of territorial limits of the constituent states, and there was no guarantee about their territorial integrity. Undoubtedly. Question is, can they be turned into union territories? Of course, they can be changed territories. No difficulty. That's express provision. And note the word, if your lordships were to read the word union territory for every word state, in Lord Article 3B, then Lord result will be absolutely very, very unbelievable. So Lord, although the explanation says that state includes union territory, but if you were to read it,
This is Dave. I didn't want to interrupt, but if it can be done for the state, why not for union territory? Until unless there's something you can make out otherwise, and when the explanation goes, explanation says state and union territories use interchange.
Lord, I must tell you, Lordships, I am not dealing with that part of the argument which has
That's
been
fine.
very beautifully
Okay, then we
done
come down.
by my worthy predecessors. But Lord, I must tell you, Lordships, that what is really worrying me is this. Your Lordships are right, it can be done. Question is that, Lord, if it can be done in Jammu and Kashmir, why can't it be done in Gujarat? Why can't it be done in Maharashtra?
Okay.
So, Lord,
Let's
that's
move further.
something
Let's
which you
proceed.
have to bear in mind. It
Let's
can't
proceed
be
further.
done. Now, Lord, please turn to para 44. Straight at page.
L15.
Therefore, our conclusion is that it would not be competent to Parliament to make a law relatable to Article 3 of the Constitution for the purposes of implementing the agreement. It is considered by learned Attorney General that this conclusion must inevitably mean that the law necessary to implement the agreement has to be passed under Article 368. Then, my Lord, 368 is extracted, and then your Lordships may kindly turn to, my Lord, page 516, para 47. On the other hand, now, my Lord, this is very important. Just see, my Lord, how your Lordships were viewing, my Lord, democracy. On the other hand, it's to be passed under Article 368. It has to satisfy the requirements prescribed by the said article. The bill has to be passed in each house by a majority of the total membership of the house and by a majority of not less than 2/3 of the house present and voting. That is to say, it should obtain concurrence of a substantial section of the house, which may normally mean the consent of the major parties of the house.
Like we'll come tomorrow.
So, Lord, look at it this way. Your Lordships not construe even majority, not to be major parties of the House,
Now,
meaning that you must carry everybody on board.
After this, we have Mr. Dwivedi will be arguing, or Mr. Nafik. Like, between the three of you, if you could please request that, could you apportion the time so that, by lunch tomorrow we have completed with Mr. Dave, Mr. Dwivedi and Mr.
I said 2 hours, but I'll finish in 1.5 hours.
So David, could we do this? Maybe if we give an hour to Mr. David, 10:30 to 11:30 tomorrow, then Mr. Nafade about half an hour. Would that be all right? Would
Require at least an hour.
make it?
Each one of us have his own nuance. I will see that overlap is minimal, but some overlap is bound to be there. It can't be here. So this is not faced with the situation with the not against the other.
What we were thinking was that by tomorrow, because tomorrow is Thursday we complete one side, so that then next week the other side can open. So
I'm told
Could we-
the workshops are continuing on Friday also.
No. Friday is miscellaneous. So if you could, in the evening today, just as you step out of the court, Mr. Dave, Mr. Nafade, Mr. Dwivedi, and Mr. Siu Singh,
My friend here.
Mr. Gopal, I don't know, Gopal
No, I am- I am also
is
appearing in the
moving force
matter.
behind many of the arguments which have preceded him. And then Dr. Menaka.
Virat, I am appearing in the matter.
So, the sixth of the Learned Council, if you could just meet for 5 minutes after we rise, between all of you, so that, we wrap up by tomorrow on this side.
My friend invites us to a coffee.
Not possible.
Absolutely. Interveners may give us short one-page written submissions on both sides, so that, interveners can give us one-page written note on both sides. So we will not hear interveners on this side and interveners on this side. We'll have written notes of arguments, I think.
But I must point out on this side, except the government, rest are interveners. So they may be.
But then, my lord, we have, just as the petitioners challenge it, we also have an interest in seeing, my lord, that
All right, we'll see tomorrow. But what we'll do is, please do sit down tomorrow between yourselves.
Indulgence is required in a matter like this.
So Mr. Parekh is also there. So between yourselves, if you could just apportion time so that, we are not, we don't really err in the side of giving someone more than.
I think your lordships will have to give us Tuesday. Considering the amount of seriousness with which my distinguished friends, Lord, all of them have been.
All right. We'll give you up to Tuesday. But tomorrow tomorrow, if you could please do this, that you can give us now exactly how we'll finish our wrap up with by Tuesday.
Really kind of.
So just 5 minutes, if all of you sit down on this side after we rise, it'll help.
Absolutely.
Thank you. Certainly.
Deeply obliged.